employer in town coming to learn something about immigration. Thank you. And anyone just an interested community member who wanted to learn a bit about immigration? It's a complicated topic, so I appreciate your interest, and we're happy to be here and teach you some things. So, thank you for that. All right, so I wanted to introduce myself. I appreciate the introduction, Rita. I have a hometown connection here in Yankton. I am a graduate of Yankton High School in 2013. Go Bucks, go Gazelles. I grew up watching Mount Marty basketball right down the hill from here, go Lancers. And I've always felt very, very connected to Yankton, and I'm very thankful that I found a place to keep immigration law nearby Burlington, that I can connect to Yankton and provide this, education. So I'm going to give a little bit of a hometown speech. So I found a phrase the other day that's a little bit of wisdom that I carry with me. That's, no man steps in the same river twice, because it's always a different man and a different river when you do it the second time. And I thought that was apt for myself coming back home. I always feel that way. I kind of see how Yankton has changed, and I see it differently because of the changes I've gone through, and also we're the river city, so I feel like it's a good little metaphor there. So the first time I came back to Yankton in 2018, I spent some time volunteering in the community, working in the community at the school district, teaching English as a second language on the Literacy Council, and that really opened my eyes to the immigrant community in Yankton, which I didn't really see growing up. I wasn't thinking about growing up, and it showed me the challenges they face, and that there's a need for service and a want from the community to bridge those gaps and work in that space and make those connections. So now that I've come back after law school, I again see that things have continued to change in my absence, and I've continued to learn and grow, and I'm very happy to be here and to bring Kiva Law to Yankton so that we can help Yankton grow and help the immigrants that are here, whether they're international students or immigrants living in the town, working in the town, feel welcome and learn more about what that process is like. So I will stop being sappy in the microphone here and start introducing my great colleague from Kiva Immigration Law. Garrett Liebring is our Associate Director of Employer Relations, and I'll be passing on the mic to him shortly. And Aaron Schutte-Wodzinski here is an attorney, the founding attorney of Kiva Law, and we have Cece Lopez Diaz-Jensen, our Kiva Law Fellow, here today to speak to you with some Cuban background as well, which is, I know there's a large Cuban population in Yankton, so we have a little connection there. So without further ado, I'll pass it off to Garrett, and we'll start talking to you about some business side of things.
Excellent. Thank you, Jacob, and welcome back to Yankton. Garrett Laffering, I'm the Associate Director of Employer Relations, and after spending 4 years in medical, a couple years in food and ag, everybody's talking about talent. There's a lot of creative ways in which organizations can utilize that international talent. There's often a lot of misconceptions also associated with that. We're going to dive in and demystify that here in a bit. But it was about a month ago, Jacob, maybe a little over, when Jacob joined the firm, and he expressed that he's from Yankton, South Dakota. He's like, do you know Rita Nelson? I said, well, I haven't really hardly been to South Dakota in quite a while. I live in Mankato. I drove from Mankato this morning, and I connected with Rita very quickly. And 2.5, 3 weeks later, we have an event, a multifaceted event that will be taking place throughout the day. This morning's session focused on businesses and employers, international students, higher ed, how can they utilize and engage with international talent. And what we find is that there's an opportunity cost for employers to not consider international talent, particularly those that are utilizing temp agencies or workforce agencies. You're paying a premium. It's not always a long-term great investment, but you have to put the Band-Aid on. We have talent that is here in this region that is looking for opportunities across Minnesota and higher ed. We're seeing that more than 80% of those international students and graduates want to remain and work in the U.S. post-graduation. Well, what does that mean for that international student? As our team is going to dive in here later, there's 3 facets of immigration law: family, humanitarian, or employment-based. If that student doesn't have that opportunity with that employer, they more often will have to return to school or return home, unless there's other avenues in which we'll dive into later. And so it can be a scary time. It's uncertain. sometimes country conditions change, and so we're here to really raise that awareness, elevate the bar for employers to understand that they too can hire international talents, and if they're in a STEM field, you can hire them for 3 years post-graduation without sponsorship. And so it's a tremendous asset, it's worth exploring, and we're, again, just really excited to be here, especially to join you in this beautiful space and to engage on your desire to be here with us to learn more about the ABCs of immigration law. So thank you. At this time, I will turn it over to Erin Schutte-Wadzinski, the owner and attorney at Cube Immigration Law. Thank you.
Great, thank you, Garrett. Well, and good morning, everyone. It's so nice to be here in Yankton this morning and to see all of you today. We are going to try and cover a lot in this 90-minute session. I'm going to spend the majority of the time today talking about the pathway for international students to get into the pipeline with employers and be able to have opportunities to remain in the United States, and how employers should take deliberate efforts to build that pipeline to make it possible for international students to integrate into your workforce. But I know that that's not all that you are here to learn about today. And so we're also going to talk strategy for how employers can best support the immigrants currently in their workforce. I'm thinking about immigrants who have employment authorization cards. They're here in the United States and they're working, but do they have a pathway to greater stability and security in this country, aka permanent residency? And there's a lot of value in employers kind of understanding the pathways for immigrants to obtain permanent residency in the United States. So we're just going to try and get a lay of the land here during this time. I love answering questions, and so I'm going to try and breeze through these slides and then leave time at the end to answer your questions. So jot them down if you have them. I discourage individuals from asking specific questions related to a specific person. But if you have general questions about trends that you experience, either as like international students or as employers or as community members, things that you're seeing in town, please do raise those, because it's important to have these conversations. If you're wondering something, it's likely that others are wondering it too. So looking at this, this is a graph from a recent study from the Green Scene State of Ag Survey. And this is from southern Minnesota, so from a couple hours away, where an organization polled employers about whether or not they have considered hiring international student interns. Because if you are thinking about competitive advantage with your peers, you're thinking about like how can you tap into the international student applicant pool? And if you're not thinking about tapping into the international student applicant pool, I think you're behind. There's others who are going to be ahead of the game and getting talent that you are not willing to access. But you're in the same boat as a lot of employers if you're thinking about, ooh, I haven't done that yet. And currently, according to the survey, 48% of companies in southern Minnesota have not considered hiring international student interns. An equal number say yes or maybe at 26%, but it's alarming that nearly half haven't even considered it. However, there's another question saying if you had human resources or legal expertise, then would you consider hiring an international student at your company? And then it would be a total of 87% saying yes or maybe we would consider it. So that shows to me that a lot of it is not necessarily an absolute unwillingness, but lack of understanding and feeling like more knowledge is needed before jumping into unknown territory. So thinking about international students, who are international students and how can we describe them? Well, before I moved back home to Worthington, Minnesota, where I was born and raised, I worked with international students for 6 years in higher education. And during my time there, working with international students, I realized that international students are ambitious. They take initiative, they strive for excellence. And how can I say that? Well, international students have gone through a lot of things to get to where they are to study in the United States. So first of all, someone living outside, who is an international student? An international student is someone who is not a United States citizen, and they come to the United States specifically to study. That is their primary purpose. And the way they come to the United States is typically on an F1 student visa. This is a visa that is a temporary visa. It lasts only as long as they are studying or getting work experience connected to their studies. And we're going to talk about that big piece of work experience connected to their studies in a few slides. But first of all, someone who wants to study in the United States as an international student, they need to take exams to prove that they are sufficiently proficient in English to be able to excel in an English classroom, first of all. They need to complete their secondary level schooling in their home country, and they need to apply to a college in the United States. They must have admission, an acceptance letter from an accredited college or university before they can even apply for a student visa. Once they are admitted to college, they take that acceptance letter and submit an online application to the U.S. Embassy in their home country, indicating an interest in studying in the United States. The U.S. embassies, so this is the Department of State now that is processing requests for international students to come to the U.S., and those applications are reviewed on a discretionary manner. So not everyone who has taken all those steps to study in the United States actually gets a student visa. And sometimes the processes can be really long and grueling. And so for someone to have successfully navigated all of those steps to arrive in the United States with their visa ready to study are already successful in my eyes because they've handled and managed a lot successfully. There are over 1 million international students currently studying in the United States. And there was a significant dip during COVID, which is understandable, but that number has really rebounded in the last couple of years, back up to 1 million students. And even though, I mentioned a minute ago that approval for these student visas is arbitrary, there is a lot of proactiveness and initiative on behalf of the Department of State to encourage international students to come to the States and study, because the federal government, long-term strategy, big picture thinking, recognizes that international students are an asset to university campuses and to our communities. So thinking about who are the international students and what are they studying, the greatest number of students are actually graduate level students. So maybe they have gotten a bachelor's degree in the United States and are continuing on to get their master's or PhD or professional degree, or they got their college degree back home in their home country and are coming to get additional expertise in the United States. There are nearly 350,000 undergraduate international students who are currently students here, and then 200,000 of them have what's called OPT. Does anyone know what OPT stands for? We're entering alphabet soup of immigration law. OPT stands for,
Optical training, practical training.
Yeah, you got it. Optional practical training, OPT. And optional practical training is an opportunity for international students to get their foot in the door with employers and get work experience, work legally in the United States with getting authorization through their F1 student visa. The employer doesn't have to sponsor them, doesn't have to submit extra paperwork. That OPT is available because it's a built-in benefit to the F1 student visa. So thinking about who can work in the United States, I'm sharing with you that international students can work in the United States. Those on F1 visas or J1 visas. J1 visas are just another form of an international student visa. They're less common, but they are primarily used for research positions with universities. Additional statuses for individuals who can work in the United States are those with an employment authorization card. I don't know if you grabbed a sheet when you walked in, but I have some handouts here that have an example of an employment authorization card. And you employers might see this if you process new hires. But an employment authorization card has validity dates. It has a start date, it has an end date, and as long as an individual who holds an EAD, as we call it, can work while that card is valid. So there's a wide range of ways someone can get employment authorization, but it is typically tied to a larger type of application. So an EAD is a benefit of some larger type of case. So for someone who has DACA, they get an EAD. Someone who is seeking asylum or has already been determined to be a refugee can have an EAD. Individuals who have TPS or have been a victim of a crime and have applied for relief through VAWA or a U visa can get an EAD. The next level of sort of security and stability in the immigration system is to obtain permanent residency in the United States. And permanent residents can work in the United States indefinitely, very few restrictions. And individuals can obtain a green card or lawful permanent residency through a family member, through an employer, or on their own based on a humanitarian circumstance. After being a lawful permanent resident for 5 years, people can apply for U.S. citizenship. You can't, if you're not born in the United States, you cannot become a U.S. citizen until you become a permanent resident. So it's a required step in the process. And typically, you are a permanent resident for 5 years before applying for U.S. citizenship. But once you are a U.S. citizen, you can apply for a U.S. passport. You can get any job that you wish, as long as you dream hard and go for it. And you also then carry some rights to sponsor your family members too, once you become a U.S. citizen. So it's just valuable to kind of see the different tiers of ways that individuals who were not born in the United States can work in the United States. Well, let's dive into the F1 student visa and how those international students can obtain employment through an employer. So this is a lifespan of an F1 student visa. With here, there are new arrivals to the United States on the far left, and say they're doing a 4-year bachelor's degree. This red represents their course of studies, full-time student. This purple part here is what's considered pre-OPT, optional practical training, while someone is still a college student. Summer internships would fall into this purple little category here. The time immediately following graduation, where someone wants to get work experience for the first time, they can use OPT, post-optional practical training, and that's what this shaded blue category is. Now for someone who has a degree in STEM, so science, technology, engineering, or math, they may be eligible to extend their optional practical training for an additional 24 months. So that means employers, you can hire an international student for 3 years before you ever have to submit any sponsorship paperwork or pay any fees for them. And that's really critical, I think, for you to know upfront. There is a way for you to create a pipeline of hiring international students that is not expensive, that is not burdensome, or is not even really tricky. It can be done, and if you find the right student for your company or for your organization, you may then want to realize like there's someone that you want to invest some additional resources into so that they can work for you beyond those 36 months. Now, the 36 months is only available for those who have a degree in STEM. If the student studies something outside of STEM, then that OPT is going to be limited to 12 months. So I'm going to kind of start from the left side with CPT, Curricular Practical Training. And CPT is when a student has a syllabus for a course that they're enrolled in that requires experiential learning, an international student can take part in that experiential learning through curriculum practical training. Now, if a student does not submit the necessary paperwork, simple paperwork, but still paperwork that the student must submit, the student is only eligible to work on campus as an international student. So if they're in a course and they are required to get experience off campus, that student will submit a form for curricular practical training. And this will allow them to work typically up to 20 hours a week off campus. In order to get the CPT, it just takes an offer letter from an employer or like an agreement between an employer and a university. And then the intern asks the International Student Office to just update their I-20, which is a governmental form indicating that they're a current international student, just to document that the person is working off campus through CPT. But it doesn't cost any money, and an international student does not need an employment authorization card or one of those EADs to work off campus through CPT. So this is like the very first entry point employers can have to building that pipeline for hiring international students. Yes?
Question, so theoretically then through CPT, freshmen and sophomores would be able to potentially work part-time off campus if they do have the paperwork, as long as all it takes is something with experiential learning in the syllabus?
Yes.
And so because typically here, either juniors or seniors are eligible for the formal internships.
Yeah.
They can't do an internship that's accredited prior to their junior year. But we've got some freshmen in the room who are extremely talented, and there is potentially a pathway then, is what you're saying.
Sure.
Can we visit afterwards a little bit more about how to
Yes,
how to go about
absolutely.
doing that?
But this CPT is really the first entry point. And Garrett, if you wanna.
Yeah, typically it's after the first 12 months of a student being enrolled. It also goes to according to university policy. But so the freshman student comes, let them get like up to speed when it comes to being a student, first of all, here in the US. Now, looking at that sophomore year, that transition in the sophomore year can be a nice opportunity for that international student to gain some CPT experience, but it must be a part of the curriculum, meaning, they have to take it for credit. And so, when it comes to the university side, and this is something we can dive into later, is how do you structure your course credit load to include more opportunities for experiential learning through internships, co-ops, etc. And so that's overall strategy that the university can deploy to further enable a younger class, particularly of international students, to begin that CPT.
So one of our recommendations is for employers to collaborate with academic departments at a local educational institution to come up with some offerings for experiential learning. And if you see, whereas the younger students that are really in need for that experiential learning, but no opportunities exist, work together to build that into courses and majors and curriculum, so that it is a possibility for even some of the first or second year students. Yeah.
Does it have to be just during that semester for that class? Or can it be ongoing, that CPT experience?
So it has to be during the semester. An international student could work for the same employer, but it would then the status would transfer to OPT, which we will talk about next.
Could I ask one question too? On the normally 20 hours or less, can they work more than 20, or are they jeopardizing their visa if they work more than 20?
So jeopardizing your visa, probably not. But if you work more than 20 hours on CPT, then that amount of time is going to start deducting from the 12 months of OPT you have available after you graduate from college. So we kind of want to be strategic, and if you can stay under that 20 hours, it will grant international students more time to work in the long run. So the pre-completion OPT, optional practical training, is generally used for international students to get summer internships in between school years. And in order to use this OPT, an international student would apply for a summer internship, get an offer from an employer, and then the student would submit an application for an employment authorization card. The international student must receive that EAD, so that red ID that's on the handout there, with proper validity dates encompassing the summer internship before the international student can begin working. An application for an employment authorization card is very simple. We here at Keep Law do them all the time. There is a government filing fee of $470 that you pay online when you file the application online. But that is the only cost to obtain the documents that you need to take advantage of pre-OPT, have a summer internship, and that $470 is paid by the student. So employers out there, you would be hiring an international student the same way that you would be hiring a US citizen. It's not any extra paperwork. It's just that the documents that an international student will present when they complete their I-9 will be an employment authorization card and their social security card instead of, a driver's license and a social security card. They do need that employment authorization card. So this is what I'm talking about. These are the documents that an employer would need to make copies of when buttoning up that I-9 for an international student who is taking advantage of a summer internship at your company. So post OPT, it was like the blue shaded area here, and every international student is eligible for 12 months of OPT. The only exception would be if someone is pursuing like a second bachelor's degree and they've already used OPT on their first bachelor's degree. The system is designed in a way where you are progressing in your academic fields and getting more and more advanced degrees if you want to take advantage of this OPT. But it's good for 12 months, but again, the student must submit a brand new application for a brand new employment authorization card and get that card in hand before they can start working. So it takes initiative and preparation on part of the international student to get that job locked in well before graduation, so that way they have time to submit the paperwork and request that employment authorization card and not have government processing slow down their ability to start working after graduation. Yes?
If we have an international student doing a summer internship and is receiving college credit for that summer internship, do they still need the authorization card, or can they go through the CPT paperwork through the institution?
Well, I think CPT would be a possibility, and it would just be, we'd have to look at the paperwork. But if the student is getting college credit for the internship, to me, it sounds like a ripe CPT opportunity.
Thank you.
Aaron, another thing to add too is that if a student utilizes CPT and OPT when they receive their bachelor's degree, they can use this to the full extent. Now, if they go off and get a second an upskill and get a master's degree, that OPT completely renews, and so they are then eligible for that 12 months. The only caveat is that you're typically only eligible to use that STEM extension 2 years once. So bachelor's, 1 year of OPT, master's, another year of OPT, if that's in a STEM field, 2 additional years.
Yes.
Can I just ask, looking in the room, so looking at STEM, what falls under STEM? Like, is it healthcare, is it
I'm glad you
engineering?
asked that.
Yeah.
So this slide here just says there's a lot of international students studying in STEM. Over half of international students are choosing an academic field in STEM. And what exactly is STEM? Well, the US federal government defines what is STEM for our purposes of who is eligible for STEM OPT. And I provide the link here to the website that lists all of the fields of study, but it's based on major. And for those of you who are part of higher ed, understand that there's a SIP code for every major. And that SIP code is defined by the federal government, whether or not that code for that major falls under the STEM field. So for example, there are some majors that involve communication, journalism, and other related programs that fall under STEM, presumably with the technology side of things. However, nursing does not fall under STEM. And there's a lot of back and forth, and there's a lot of advocacy actually at the federal level to try and get more careers on the STEM list so that more international students can work longer, get that 24-month STEM extension, especially in careers where we don't have enough workers in this country. And I think healthcare is a prime example of that. So I'm not going to dive into exactly what is or is not on the STEM list because it's a 12-page list, but I encourage you to check it out to see whether or not the types of fields that you're looking to hire qualify. But if you're thinking like your job description could potentially loosen itself a little bit on what type of majors you require, you could cater a job description to include STEM majors that are on this list and specifically seek out students who have degrees in STEM related fields. So we also encourage like department chairs at colleges and universities to strategically designate interdisciplinary majors with zip codes that are included on the STEM list. So you can kind of cater the description of a major to be categorized as a STEM major if there's an interdisciplinary major that you can be creative about.
And international students in the room, think about what your major is. Figure out if it's STEM. If you're a business administration student, you do not qualify for STEM. However, if you're business analytics, and maybe it is only an additional 6 or 9 credits, that then allows you to dual major, one of which is in a STEM, you are then STEM eligible. So be mindful of where you are, like where you're at in your journey, and what qualifies as STEM and non-STEM, because there's certainly strategic opportunities for those students that go down the STEM field. In fact, we see a lot of students that will first enter the workforce on OPT with maybe a general undergrad bachelor. They then go back to get a master's degree in a STEM field. And so it's something that they wish they knew sooner. You freshmen, this is about as early as it gets. Be sure that you're familiar with these resources.
so I'm gonna move past this quickly, but, so the additional 24 months, for STEM OPT, the employers do have to be registered in E-Verify if they are going to hire an employee on STEM OPT. Most employers are, and it's not too difficult to get registered if you're not. The employer also needs to complete a training plan for STEM OPT students. It's a short form that is submitted to the government, just explaining what kind of ongoing training someone on STEM OPT is obtaining to continue to develop professionally. The student, again, would have to submit another request for an employment authorization card that has validity dates for an additional 24 months, but that $470, again, is paid for by the student. All right, so an international student will eventually hit the end of the road in terms of employment authorization, but I hope you now understand that the benefits of an F1 student visa does not end at graduation. There is at least 12 months, maybe up to 36 months of employment opportunity for international students to be gaining work experience in the United States. But what happens next? So the international student may be consider going back to school. They may want to return home. They may have a family-based pathway to permanent residency, say they've married a US citizen, for example. They may have a humanitarian-based pathway, which we'll talk about in a bit. Or they may have a really good relationship with an employer, and that employer is ready to take some next steps to ensure that that student can work for the company for a longer duration of time beyond their OPT. So what are those options? One option is a TN visa if the employee is a Canadian or Mexican citizen. So the TN visa was created through the NAFTA trade agreement to try and spark more movement for professionals. And so employers in the United States can hire Mexican and Canadian professionals, typically individuals who have bachelor's degrees, on 3-year work visas. And the application process is one where the employer is in the driver's seat and the employer is paying the fees, but it's simple. TNs are some of my favorite visas because it's simple, easy, and quick. And not all visas are this way. So if you have an employee with the right nationality and the college degree, the TN visa is going to be your golden ticket, because these are 3-year work visas that can be renewed every 3 years for an indefinite number of times. Spouses and children can also get derivative visas under the TN worker. The student or the spouse and the children cannot work in the United States, but they can study in the United States on this derivative TD visa. This here is a list of the professions and occupations that TN visa holders can fill. You can see that they are professional occupations, including a lot of healthcare occupations. So the TN visa is a very popular visa for healthcare professionals. We just got done talking about STEM OPT. You'll notice there are a lot of STEM professions on this list, but they do not fully layer on top of each other. So just because someone is eligible for a TN visa doesn't mean that they had been eligible for STEM OPT or vice versa. There's some overlap, but not exactly the same. The H-1B. This is a popular visa. It's perhaps the most well-known work visa that employers will submit applications for. An H-1B is available to individuals from almost any country around the world. And like the TN, it's a 3-year temporary work visa. It can be renewed only one time for a total of 6 years, but it can be for nearly any occupation as long as that occupation is considered a specialty occupation that requires a minimum bachelor's degree. So this is for college degree holding international workers. Like the TN, an H-1B visa holder can bring their spouses and children to the United States where they can live and study, but they cannot work, again. But the H-1B is so popular that there are more employers wanting to snatch up these H-1B visas than the annual number of H-1B visas available. So the federal government issues only a set number of H-1B visas every year, and they actually use a lottery system to figure out what employers can actually take up these H-1B visas and use the visas to hire international workers. The lottery takes place in March of every year, and you must submit the H-1B registration before the lottery deadline. And there's one major pull for the lottery, but sometimes there's a second and third pull later on in the year if the employers who were selected the first time don't actually follow through with their application, or the applications get denied. So people who aren't selected on the first poll still have hope, but we're seeing that only like 25% of employers were selected for the H-1B lottery last year. So it's highly, highly competitive and completely random. So I like to be in control. I like predictability. I don't like the H-1B when it comes to employers that have to submit a registration for the lottery. But there is an exception to this in that not all employers have to go the lottery route in order to get an H-1B. There is a cap exemption, meaning that there's certain categories of employers where there is an unlimited number of H-1B visas available to them. So an employer who is an institution of higher education, so Mount Marty folks, you don't have to deal with the lottery system. Nonprofit entities related or affiliated with institutions of higher education, such as public schools, K through 12. Nonprofit government research organizations and government research organizations are exempt from having to deal with the lottery. So Kivu immigration law, it has done really well with working with public schools that are dealing with teacher shortages, using the H-1Bs for hiring international student teachers. We can do the process within like 30 days. And so, teachers go through the regular route, trying to hire teachers through their normal channels, and if they aren't able to fill certain positions, then they can consider the H-1B as a backup and process that request relatively quickly, as long as you have a teacher in mind. Okay, yes?
So the employer is the one who applies for the H-1B visa, and then once they're approved through the lottery system or they're one of those exempt categories, then they can hire whoever they want to bring into that H-1B, and then that person gets the H-1B. Is that correct?
Yeah, so it's a question about who initiates this process and at what point do you actually extend an offer to an employee. So the employer is in the driver's seat again for the H-1B, and they submit a registration for the lottery for a specific employee. So by March of a given year, if you are an employer subject to the lottery, you would need to know what individual you wish to hire on an H-1B, and that potential employee's name would be included in the registration materials that you submit for the lottery. Does that answer your question? Okay, yes. So I'll just say there is kind of a way to piggyback. So for you employers who are cap subject, meaning that you have to enter the lottery and you're thinking, well, this isn't fair. There is a way that you can piggyback, and it would be partnering with a cap exempt organization that is the initial applier of an H-1B. But if you sponsor someone for an H-1B, that employee must work for you for at least 5 hours a week. So if Mount Marty, for example, filed for an H-1B for someone to work for them for 5 hours a week, a cap subject employer in town could piggyback off of that and file a concurrent H-1B application for someone to work 30 hours a week or 35 hours a week at their for-profit entity, for example. And as long as there is that partnership where the employee truly is working for both employers, it is the cap exempt employer that is paving the way to avoid having to enter the lottery. Yes.
Do you happen to know offhand if nonprofit adult education programs fall into the nonprofit higher education category?
It would depend on if you have ties to a university or college. So the way that public schools typically have ties to a college or university would be if they have an MOU for PSEO, like having their high schoolers be able to take college classes, or if the college offers, any type of offerings to students throughout the year, student teaching agreements or things like that, that's enough to create ties. So each organization is separate, but if you can show some ties to that institution of higher education, and you're a nonprofit, then you're cap exempt. Yes.
And it kind of hit me going back a little bit to the TN visa with the relationship with Mexico. Since some of our employers have plants in Mexico, is that something that can work with them to better utilize staffing or moving positions from, or employees from Mexico up to work at open positions in Yankton?
Yes, so that company in Mexico could be a feeder, potentially. The TN visa really cares about the employee's citizenship. So the employee has to be a citizen of Mexico or a citizen of Canada. But there's a lot of different ways that local employers can partner or kind of create recruitment streams. And if companies already have established ties in Mexico, then it might be an easier, they would have an easier time, getting people up here. Yeah. But there's also a visa called an L visa. It's an intra-company transfer visa for someone typically high-level managerial position working at a company abroad. But there's also a company in the United States. They can come work for the same company in the United States on an L visa.
So employers have to pay to enter the H-1B visa?
Yes, a small amount, and it used to be $10, but they just raised the price. So, but it's fairly minimal. It's fairly minimal, but yes, the employer is responsible for paying the cost of the H-1B visa. And as we lead into employment-based permanent residency, the employer stays in the driver's seat kind of from here on out. So if an employer stays in the driver's seat from here on out. If an employer is really confident in one of their employees who is not a U.S. citizen and is on a work visa, an employer can take the step to help that employee get permanent residency through the employer. And that's called employment-based permanent residency. It has a whole lot of other names, but I try to streamline it, but you might hear a green card, sponsorship, an immigrant visa, an EB2 or an EB3, an NIW, which is National Interest Waiver. All of these mean permanent residency. So up until this point, we've had, this conversation has been all about temporary work in the United States. None of the options we've talked about thus far on their own lead to a pathway to permanent residency or U.S. citizenship. So if you're thinking about employees who you want to support becoming permanent residents, then you have to get on this train of employment-based permanent residency. There are 3 tracks to getting a green card, and employment-based is one of them. The other tracks are family-based immigration through a U.S. citizen or permanent resident family member. And then the other track is a humanitarian track where the international or immigrant student would be applying for something on their own based on humanitarian reasons. So I'm not going to go into the nuts and bolts for how to sponsor an employee for permanent residency, but it's just important for you to know that it is possible, but it takes a long time. It takes a really long time. And while the employee is waiting for that process to complete and for them to get permanent residency, they must maintain lawful status in the United States or return to their home country and then come back with their immigrant visa or green card in hand. So it's worth having a conversation with an immigration lawyer, because once you get to this stage, you're definitely gonna wanna work with an attorney, to be honest. But have the conversation as soon as possible so you can start planning out that timeline for when you would initiate the process for sponsoring an employee for permanent residency. There's also something called a national interest waiver, where someone with a master's degree or higher would essentially petition themselves without an employer for an employment-based green card, and that's possible if their line of work or research is aligned with the government's public interest. If you've published a lot, if you're really prominent, you could qualify for a national interest waiver. So I mentioned that there are 3 tracks to permanent residency, and it's, employers shouldn't feel the burden that it's all on them to help their employee get permanent residency, because the employee may have a pathway to permanent residency through a family member or have a pathway to permanent residency based on the humanitarian track. What's really wise for an employer to do is have their employee assess all of their options and kind of think of employment-based permanent residency as the option of last resort. Like, if you love this employee, you will sponsor them, but only if they can't do it themselves. Because as an employer, you don't want to invest a significant cost if your employee can pursue residency faster and with less money than through you. So encourage your employee to have that conversation with a lawyer to assess the full situation before committing to one route or another. And there are other things that employers can do. So all of you sitting here today are taking step 1. I believe that HR departments should seek professional development opportunities to better understand the immigration system, so that you can aid in the strategic development of hiring a broader range of prospective employees. It's also a good idea to improve the sense of loyalty among employees by making legal resources available to employees. There are a lot of programs that are offered in-house or through contracts with law firms to make it possible for employees to have free consultations with a lawyer, or someone will come in and provide workshops or information to employees, where sometimes employees are also lacking knowledge about their own immigration situation. And then third, we've seen successful models where employers are offering financial support for employees' immigration applications. This might be employment authorization card renewals. It could be applications for citizenship, covering the government filing fees, for example. A little bit can go a long way when it comes to building up that sense of loyalty and trust between an employer and an employee. So we're going to touch, the bells are telling me that it's 11, so we're going to touch a little bit on the different pathways to permanent residency now. So we've talked about the employer side of things. There's also family and humanitarian. And thus far, we've talked a lot about international students. But thinking bigger picture now, think about the newcomers to Yankton. Think about immigrants who have arrived to this community over the past 5 or 10 years and are here establishing roots, contributing to our community, but may or may not already be on a pathway to permanent residency. If you employers employ immigrants who present their employment authorization card and social security card, that is a signal that they are authorized to work in the United States, but they are not yet permanent residents. So how can we create greater stability and security among your workforce in helping those individuals get on pathways to permanent residency? Permanent residents that are not worrying about their employment authorization card expiring, they're not worried about a change in policy that would make them unable to renew or continue working in the United States. Employers really should have the supportive mindset of helping their employees get onto like more stable, drier ground. And that is connecting them to those who can assess them for viable pathways to permanent residency. So US citizens who are over 21 can sponsor spouses, children, parents, or siblings for permanent residency. It's easiest for these sponsorship applications to be approved if the beneficiary, so if that international individual entered the United States lawfully or is not in the United States ever. For someone who has an unlawful entry into the United States, family-based immigration, it doesn't always, hit a dead end, but it can be more difficult. Permanent residents or green card holders over 21 can also sponsor spouses, children under 21, or unmarried children who are 21 and older. And that's something, we can talk more about family-based immigration, but I just kind of want you to know that it exists and it is a pathway to permanent residency for those who have close family members who are permanent residents or US citizens. Now, Kivu law operates largely in this humanitarian pathways realm. Our law firm is a social enterprise law firm in Worthington, Minnesota, which is right in the southwest corner of Minnesota. And we've seen a high volume of immigrants who have come to the United States fleeing violence, poverty, and uncertainty in their home countries. And when we think of humanitarian pathways, we usually think of situations like unfortunate circumstances, creating avenues for humanitarian relief or pathways to permanent residency. But not always. There is sometimes intersection between family and humanitarian options. But it's important that even international students consider whether there is a humanitarian pathway available to them in order to get permanent residency in the United States, having entered the United States lawfully as an international student, but pivoting, maybe they won't even need OPT. Maybe they can apply straight away for permanent residency based on a humanitarian pathway. So there are, I want to take a few moments to just dive into a few humanitarian pathways. So I'm going to invite my colleague Cece up to speak about these two pathways to permanent residency. And then after that, our hometown boy Jacob is going to talk a little bit about special immigrant juvenile status, which is another pathway to permanent residency. Okay.
Thank you so much. So just to preface a little bit about myself, my name is Cece Lopez Diaz Jensen. I'm a graduate from the University of Miami School of Law. And so I'm going to cover a bit of the two humanitarian programs that one has been rolled out fairly recently, while the other has existed for a very, very long time, considering the history of Cuban migrants in the United States in particular. It's my understanding that a lot of employers here are dealing with families and employees that have a Cuban American background or a Cuban background. And so that latter program there would definitely be beneficial, and especially also for the organizations that deal with the immigrant community here in Yankton. Now, the parole in place program, this is a brand new program that has been rolled out by the Biden administration. This was particularly intended for what we call mixed status families, right? Where you have a potentially undocumented spouse that is married to a United States citizen, but did not come lawfully into the United States. What does that mean? Now, lawful admission means that at some point you had contact with immigration when you first came into the United States, and you were admitted or you were paroled in, and basically given that lawful entry, right? What we're seeing is that when you have a lot of spouses that just don't have that little portion to then be able to proceed on a family-based petition, meaning they're unable to adjust their status and eventually get citizenship. So this program was kind of directed at those family members that wanted that little portion of the lawful entry. So what this offers is essentially it benefits spouses and stepchildren of U.S. citizens, again, who do not have that lawful entry status. And it is for spouses of U.S. citizens who have been in the United States since 2014, and again, are married to a U.S. citizen, but have to be before June of this year. Children and stepchildren of U.S. citizens under 21 who entered the U.S. without lawful admission are also eligible. Now, what it provides is sort of that pardon for the unlawful entry, and it allows you to then go ahead and adjust in the United States. Typically, what you had to do in the past is that you would have to return to your home country and wait there in order to go through the consular processing process. So the benefit is that you are able to apply to sort of get that lawful entry point. You then become eligible for work authorization status fairly immediately. And then it gives you that opportunity to then go ahead and seek permanent residency and hopefully later down the line, United States citizenship. The only caveat to this is that with a lot of these humanitarian programs, you do see a lot of lawsuits come out. What does that mean? There are a lot of organizations and individuals that are sort of, challenging the legal premises of these programs and whether they're supposed to even exist in the first place and whether they're constitutional. There's a recent lawsuit that's come out of Texas in particular that has sort of sought to stop this program. That is currently pending, so there's a current pause on the actual approvals of the parole in place programs or applications. That does not mean that you are not able to apply. You're still able to apply, but as of right now, there's an indefinite pause on the program. We are at Kibu Law working with other professionals who are keeping up on this lawsuit, but again, this has kind of been a revolutionary program for those spouses in particular, or mixed status families that are wanting to sort of bring their family members to the point where they are able to seek permanent residency status and hopefully later down the line, United States citizenship. And then in terms of the Cuban Adjustment Act, fun tidbit, I myself am Cuban American. I come from a Cuban family, obviously was raised in Miami, Florida. However, I was originally born in Denmark, but to a Cuban family. And so I actually came into the United States and was able to adjust status later down the line through this particular program. So this is definitely great for a lot of Cuban American families. The general sort of eligibility requirements is that they were inspected, admitted, or paroled, which we talked about what that meant earlier, and have been present in the US for at least 1 year. That means that Cuban Americans in particular have this sort of special status at this point, where they are able to adjust status a little bit faster than what we're seeing for most folks with other humanitarian programs. As Aaron mentioned, however, there's unique and particular circumstances with every family and individual, right? So we always recommend that everybody set up a consultation or speak with an attorney, a licensed attorney, that can sort of give you an idea of what immigration package best fits you. Again, this is applying to international students as much as the employees of the employers in the room, as well as the organizations that are servicing the community, right? Make sure that you're sort of evaluating what is the best fit for that particular and unique situation. But that's a little bit of a tidbit on those two programs. I think I'm gonna hand it off to Jacob to finish this off.
Thank you, Cece. I appreciate it. I'm going to speak briefly on another form of humanitarian relief called special immigrant juvenile status. So, as you can probably tell from the name, this is a status for juveniles, and the requirements to qualify for it are that the applicant be unmarried, under the age of 21, and experience neglect, abuse, or abandonment by one or both of their parents. So, going through those criteria, unmarried prong is fairly self-explanatory. well as under 21, and those are there because under federal immigration definitions, a child is someone who is under 21 and unmarried. So that under 21 age can matter a little bit because part of an application for special immigrant juvenile status, a requirement is to receive a state level court order of custody or demonstrating the neglect, abuse, or abandonment. That is the third requirement. So there can be difficulties getting those sorts of orders for individuals who might qualify but are over the age of 18. So that kind of can vary by state to state. I'm not overly familiar with South Dakota's laws, but from a brief comparison I made with Minnesota, it is a little bit harder once you are aged into being an adult under South Dakota state law to get that sort of custody or guardianship petition because you are legally considered an adult, and since it relates to treatment from your parents, you were sort of emancipated from them under the law, so it can be a little bit harder to get. Not impossible, but again, I'm not an expert in South Dakota family law, so that would be something to talk to an attorney there. But under Minnesota law, you can receive custody petitions and guardianship petitions for those that are over 18 to establish a custody through a parent or a third party, maybe a relative or a trusted family member or adult, due to a showing of abuse, abandonment, or neglect from one or both of your parents. And same thing if they're over 18 in Minnesota, you can receive that and extend that order until you turn 21 instead of ending when you're 18, and that demonstration can go into your Form I-360, which is the application for special immigrant juvenile status. Those three, like what I mentioned, neglect, abuse, abandonment, again, are kind of covered by state laws because you need that state law order. So it can depend on what your state's definitions are. But neglect can be anything like failing to support, failing to meet the needs of a child, allowing them to undertake a dangerous situation. A lot of times in our cases, we've been able to prove through demonstrating that a parent allowed their child to make the journey from somewhere in Central America to the United States without accompaniment. And that's considered neglectful under United States laws because it puts the child into a dangerous situation, and that could qualify as neglect. Abuse can be, that one's pretty straightforward, I won't go into the details, but again, it can be covered by state laws, and it's important to screen and talk about things that in their home countries might not be considered abusive, but that under American law and American standards would be considered abuse, because if you can demonstrate that and get an order from the courts here, that can qualify them for this visa. And abandonment, also pretty straightforward. If a child only lives with one of their parents, the other parent doesn't have anything to do with them, or remain back in their home country and doesn't provide any financial support or assistance, that can qualify as abandonment. Depending on state laws, Minnesota permits abandonment by the death of one parent. And you can get a petition establishing that sole parentage through the living parent that is supporting the child, and that order can be enough to qualify as abandonment for the purpose of getting SIJS. And SIJS is a very powerful form of relief for immigrant juveniles. It provides a protection from deportation, it provides lawful permanent residency, and work authorization, and a pathway to citizenship. So that's we recently had a grant, I think, from the Southwest Innovation Foundation for $300,000 to cover children in Southwest Minnesota, and we've used all $300,000 of that in what, 3 months? 4.5 months. So there is a big need for it in this area.
Helping more than 150 or 140 kids.
So we were able to cover their legal fees completely using that grant, and we still have a large volume of SIJS cases. So it's a very powerful status that is important to explore for kids in the region. And yeah, that's all I got on that. Pass it back to you, Erin.
All right, so we're gonna wrap up here. But there are a lot of, so on this handout here, there's some pictures of permanent residency cards through the ERAs and the employment authorization card that we've talked about common types of immigration cases. And we've only touched on a few of these in this presentation, but this is an excellent resource just to kind of get us a better sense of what types of pathways some of your employees or your students might be pursuing. When you look at the employment authorization card, in the middle of the card, you can see the text that says category, and under it is a letter and a number. And that category code will tell you on what basis your employee has obtained work authorization. So as I listed these various case types, I listed what category code is tied to this case for their EAD. So if someone has a CO8 category on their EAD, that means that person is seeking asylum in the United States. If someone's category code is CO9 on their EAD, they have already applied for permanent residency and they're waiting for their green card application to process. Special immigrant juvenile status has C14 and so forth. So just kind of a helpful insight, and you can also Google EAD category codes and the whole list will pop up if you are curious about how your employee has obtained an EAD. And when we think about how employers can venture into the land of expanding their workforce to include immigrants and international students, it doesn't have to be a super daunting experience. It can start with just one student, one employee, and working directly with a professional to ensure that the steps are working and that the process can operate smoothly. You don't have to have a big grand strategic plan at your company to think, okay, we are going to fill all of our hiring needs by hiring international students. If you already have a strategic plan for expanding your talent pool, then maybe you can use that as a catapult or a catalyst into integrating international students into your workforce as part of an overarching plan. But it's fine to just say you're going to start with one and see how it goes. Some of the tips that I have for you, if takeaways, if I could say, I encourage companies to enhance their relationship with higher ed institutions. As you can see with international students, it really does require a partnership to take full advantage of the benefits of an F1 student visa. So if you can partner with higher ed institutions on CPT courses, building experiential learning into syllabi and having that experiential learning take place at your company, all the better, right? You're getting exposure. You are kind of setting the standard of what it's like to work in the United States of America. You can attend career fairs, and at those career fairs, don't overlook international applicants. We attend career fairs to talk to employers, and so many employers say, oh no, we don't hire international students, we just never have. But the students who are coming up to them at those career fairs are the international students seeking opportunities, and those students are oftentimes overlooked. So be open-minded about that. And advertise summer internships through regional institutions that have international students. A pro tip for your job description is have a line in there that says, we are open to the possibility of sponsorship. This does not mean that you are contractually obligated to offer sponsorship to every international student that you hire on OPT, but it leaves open the possibility of a conversation down the road if you have that great employee. And demonstrating that you are open to sponsorship means it's more likely that you're going to be able to attract an international student, because you bet international students are going to be looking for employers who are at least open to the possibility of hiring them after graduation. International students will frequently use Indeed and other search engines, and search for jobs by keyword, and one of those keywords will be sponsorship. Because again, they're looking for employers who are at least open to the idea of sponsoring for an H-1B or some other type of visa.
CPT, OPT, sponsorship, they're all highly searched for. And typically that first entry, that international student is on CPT or OPT. So by including that language, those search terms within your job descriptions, then makes you more relevant when searched.
And present your company as open and willing to hire. I think, I talk about strategic planning, and oftentimes you can structure these efforts of, being open to hiring international students as part of your DEI initiatives within your company. It's maybe already something that your company is committed to and thinking a lot about. This can just be one additional step that you can take in helping to meet your company's goals. So I think we've probably sufficiently overwhelmed you with the ABCs of immigration law, but we just wanted to kind of help you get a lay of the land. And we're happy to answer any questions that you have about anything that we discussed.
Can I make a comment?
Sure.
For those of you that represent employers in the room, the international students have a substantially higher percentage of our top performers when you compare to the US students. So don't be afraid to hire international interns. The average GPA is higher for the most part. The average scores and test capabilities within their GPA is typically higher. And so really many of our best and brightest are international students, so don't be afraid of that.
And often multilingual.
Oh, yeah, and I have several students that speak a minimum of 3 languages fluently.
And I really do think this is very valuable for Mount Marty, for our community, for employers, because when you look at numbers within Mount Marty, that is, boosting the variety and diversity within Mount Marty, there's 70 international students. And so even on your data charts, I was looking at the map, if there's only 300,000, Yankton has 70 of those. That's pretty big for Yankton for a small university. So to put it into context, we have a lot of potential right here that I think we can really capitalize on. We've got to take some steps to do that.
We have 3 continents of international students represented just in the students we have in the room right now too. So they're coming from all over. So you've got Europe, South America, and Australia represented in the room right now as far as international students. So
You mentioned for the internships for the summer, so I work in healthcare, so like nursing students. So if they don't take the summer internship class, they have to tap into that pre-OPT. Is that what you mentioned? So if it's a 2 or 3 month internship, that takes away from their 12 months. Is that
That's
correct?
exactly correct. So if OPT is used for a summer internship, and that summer internship is 2 months long, then there would be 10 months of OPT remaining after they graduate.
Some of the questions I hear from employers is whether CPT, OPT can be paid for the student, and what areas can be paid, when can they be, and I know you said they can be treated the same as any other intern, but I think it's important to maybe hear that as well.
So they can all be paid. Right, Garrett?
Yes.
Yes.
And they should be paid. From pre-internships.
Yes, so, the recommendation is that you would pay an international student on OPT or CPT in the exact same form and fashion that you would pay a US employee. Yeah. And that international student would get a W-2 at the end of the year and file taxes just like a US citizen would.
So now you found that student on CPT and you have that experience with them. Okay, they're a good fit, likely they're a top performer. How then do you look at that strategic timeline and get them incorporated into your organization? And I think that is the most strategic thing an employer can consider. When do you get them into your pipeline? How do you nurture them throughout that pipeline and their duration of CPT and OPT post-graduation? Now you've had 2-3 years potentially with working with this individual. Do you see yourself with them another six or so years? If the answer is yes, you should be making that decision sooner than later to begin entering that H-1B lottery, because you could be afforded three chances, maybe 4, at winning that H-1B lottery. So the earlier you get that talent into your organization and you get the test drive and you have a good marriage, the student enjoys working for your organization, you understand the value as an organization of that talent, think about those longer term options, because as time fades away, so does some of the lasting opportunities that may be available.
If employers sponsor this person to earn their permanent residency, is there any kind of like agreement that the employer makes with that individual to say like, if I sponsor you, you will continue for me for X amount of time or whatever the case is?
So there is not an obligation under immigration law for that employee to remain with the employer. There are sometimes agreements that the company would devise that says that the employee must maintain employment with the employer while that green card application is pending, which seems logical. It's generally frowned upon to have a contractual agreement with the employee that says like, if you leave before X time, you have to like pay out, the fees we invested. You have to walk a fine line in terms of what is legal in that regard from an employment law standpoint. It is a concern on employers' parts. If they're going to invest a lot of money in sponsoring someone, we want them to stick around. Typically, what we've seen is that there is that loyalty built up with the employer and the employee, where there is going to be that mutual trust and understanding that this is intended to be a long-term gig. Yeah. Okay. Well, yes.
One more question. So what happens when it comes to placement for internships and you're struggling to find an internship for an international student, and they don't necessarily want to go the summer route, though it is certainly possible. We've had students that have done that and gone that route. Is there a pathway to try and be able to be proactive and find a way to make sure that happens if it's not locally, if for whatever reason they're not able to get a local internship and whether it be remote or whether it be some other manner that would be a pathway for that? Is that, I'm struggling how to ask the question, but I've had that experience more than once recently, and it's a challenge.
Yeah, and I think it's going to remain a challenge for as long as employers are not open to considering international students as employees. We know that international students are very marketable because they're smart, they've got high GPAs, they're hard workers, and they've got some unique factors such as multilingualism that is often a real asset to employers. And so I think it's a multifaceted approach, right? One is working with employers to help them open up a little bit more to international students, but also international student offices and advisors at universities to be in the know about how they can help international students navigate the job application process in the United States. I mean, applying for a job in the United States is a little bit different than applying for a job in a lot of other places. We use resumes, not CVs. Like, what is a cover letter? Some of the things that my parents were able to teach me because they had applied for a job that's not gonna be the case for an international student, and so sometimes for an international student to really be able to present themselves well and in their best light, it's going to take support from the university to help them, establish those skills that may not be skills that US or American students are gonna lean on an advisor for. So, I think it's an exciting field because there's a lot of potential. And our goal today was to help you feel, maybe a little bit less nervous about the uncertainties or unknowns. We will stick around for a little bit if you have any, questions that you would like to ask us individually. But thank you so much for coming, and I hope you have a great weekend.